Case on the docket is Sullivan versus SCHATZ Irrigation Services. Are you ready, sir?
William S. Sullivan, attorney at law, state of Florida. Here for William S. Sullivan, I am also the personal representative for this case, and also you will hear some things about the workers' compensation. I'm also the attorney of record for the workers' compensation matter.
Mr. Sullivan, let me get right to that issue then, the workers' compensation immunity. And in looking at your brief and looking at some of the pleas, I think you attempted to allege gross negligence and intentional misconduct. Is that basically correct?
Gross negligence is correct as far as the employee. I don't really like the intentional conduct. I'm going to withdraw that.
Well, is gross negligence enough to get you past the workers' comp immunity?
Gross negligence of a co-employee under the particular statute we're dealing with passes the test. Gross negligence is defined in Turner, and it's also defined in the case studied by the...
So your theory is that the co-employee engaged in gross negligence, and therefore the employer is vicariously liable for the gross negligence of the co-employee, and therefore that vitiates the workers' compensation immunity as to the employer?
Couldn't say it better myself, Your Honor. That's exactly my point, and to prove that further,
okay, I'm sorry.
The 2003 legislators removed vicarious liability from the workers' compensation law. That's their right. It existed before when you had the employer and you had a co-employee engaged in conduct which was gross negligence. The employer was responsible for the acts of the co-employee.
We're dealing with I think we're dealing with the 2001 version of the statute, aren't we? I mean,
yes, Your Honor, and it said nothing about vicarious liability.
Well, do you have any cases where a similar situation occurred where we can say that the co-employee was grossly negligent, and because the employer, who would otherwise have workers' comp immunity because of vicarious liability, would therefore be liable, and the workers' comp immunity would therefore be removed? Do you have a case similar to those factual situations?
Yes, Your Honor, but I came out the door last night without that case, and that was not really, I'm trying to find that this morning, and I did have that case, but it was not clear. It was not clear under the law that says it the way you say it.
Well, I thought, well, let's assume that the standard is that you have to show, in order to go beyond the workers' comp immunity, that on the part of the employer, that there was substantial certainty that injury was going to occur.
That's only as to...
Can you meet that standard in this case?
I don't think so, sir. I really don't think so, and I didn't like it. I was not the primary attorney in the case below, but I didn't like that, and I came here this morning to say I'm going to withdraw that argument, because even talking about this man who was completely reckless in his driving.
Gentlemen, what argument are you going to withdraw? I'm not sure.
That the employer has, whoever the employer is, I don't know that question. That question's never been decided right.
Wasn't there evidence presented or an affidavit presented by one source that these people were?
Your Honor, workers' compensation attorney who filed an affidavit in this case, he also filed an appearance in the workers' compensation
Right,
case, and he said the employer is one source of Pennsylvania, Plymouth Meeting, Pennsylvania, and that is not one of the one-source conglomerates. You won't find that as being listed. So we have a employer and attorney coming in who filed affidavit, and I filed an affidavit showing what he filed in the workers' compensation case, that I am the attorney for the employer. The employer is one source located at Plymouth Meeting, whatever it was, the address in Pennsylvania. And that is a completely different employer than one source of
Okay, well,
Georgia.
let me, I think you lost me, because you said you were withdrawing an argument. What exactly are you withdrawing, and what exactly is your position here today relative to the workers' comp immunity issue?
First of all, my position is there is no workers' compensation immunity because we have an issue of fact, which Hall versus Alka, so they have to prove a negative. We have an issue of fact. Who was the employer? So we should never have reached that on the summary judgment basis because we don't know who the employer is. It's a question of fact to be resolved by the
Okay,
jury.
for the purposes of argument, what if we say, is it one source or one stop? Yeah, one source. What if we say it's one source? What if we say that the record is clear that the employer is one source?
One source is just saying it's almost a generic term. There's a one source, there are hundreds and hundreds and hundreds, and there's different one sources in the state of
Okay, the
Florida.
summary judgment was rendered in favor of One Source Landscape Construction, Inc., DBA One Source. Okay, well, so let's assume, for purposes of argument, that we look in the record and say, okay, well, there's no issue, that's the employer. Then what?
Then we have to, that's why I'm arguing, then we have to say that it was responsible for that one source, not the one source of Pennsylvania who we have information that could be the employer, but the one source of Florida, which is the one source of Georgia, which I'm not sure of. That's why I wanted to have the determination.
Okay, but let's assume there's no issue as to who the employer was, and the summary final judgment was rendered in favor of One Source Landscape Construction, Inc., DBA One Source, and let's assume that we say that, for purposes of argument, that looking at the record, we say that was the employer.
Yes, sir.
Okay, then where do you go from there?
Okay.
Concerning the workers' comp immunity.
I'm going to go down a branch, if I may. And at one side of the branch would say that one source is responsible by concept of dangerous instrumentality and or vicarious liability for the acts of their employee if he engages in gross negligent acts to a co-employee.
What if we say that's not the standard, and that the standard is substantial certainty? You said you've already conceded.
I find that strange because I haven't found a case that says the vicarious liability, the standard is substantial certainty. That is the standard. It's not even written into that particular act, 44011 or whatever we're talking about. Now, that is engrafted by law, starting with the Turner case,
Well,
says,
okay, I'm sorry, go ahead.
which says there's responsibility and defines culpable negligence for a supervisor. I'm not saying there's culpable negligence right now on the supervisor. And gross negligence on the employee and substantially certain to occur on the employer. It doesn't say the employer gets a free pass. They actually talk about gross negligence of the employee and responsibility of the employer for an employer situation. They do not talk about the vicarious liability. The other thing that I would draw your attention to, there was an affidavit filed, 2 affidavits filed in support. And in the affidavit filed by the president, I guess he's the president of all these corporations, I'm not sure, but he states there that there was a accident that occurred, and that he has personal knowledge of the following. We, at one source, always had a strong policy that you don't take a vehicle unless you're authorized to take the vehicle. Mr. Cruz says the driver of the vehicle was not authorized to take the vehicle. He didn't have a driver's license. We would never let him drive. He was driving. This is our policy. It was set forth in their affidavit. And no one has the authority to violate our policy. No one has the authority to give him the vehicle to drive. And everyone of that crew, including the decedent, who I represented the survivors of the decedent, even he would know about the policy that was wrong. I bring this up because the workers' compensation law says this is a deviation from employment. So if there's no employment relationship, he's not in the course and scope of his employment under workers' compensation, there's no workers' compensation immunity. That was the other branch I was going down. These issues have to be decided by jury.
I mean, that argument is if you're violating a company policy, you're not in the course and scope of your employment, even if you're doing things that are related to your work. Is that, I mean, if he was driving them to a workplace to do work for this employer, the fact that he is violating a company policy in your argument means now he's outside the scope and there's no immunity?
There's 2 points in there, Your Honor. I'm glad you brought that up. One point is, how does the person, and that if they do not own their vehicle, they're not driving with the knowledge and consent, they're not an owner. There's a question about Austin Irrigation, not Austin Outdoor. That's another corporation. Austin Irrigation owning this vehicle months and months and months and months. It was never transferred. So I understand your point. Your point, if I might say, Your Honor, that we have a situation that we're talking about workers' compensation law, and we're talking about the immunity coming from workers' compensation law. It doesn't come from any place else. We're talking about the wording of the statute, and it says if you deviate, you're not in the course and scope of your employment.
Okay, so if the company policy is you're not allowed to speed in our vehicles, and somebody's on their way to the job site in the company vehicle, and they drive 70 miles an hour in a 65 zone and get in an accident, your argument would be no immunity because they're outside the scope of their employment because they violated a company policy?
I think it's a little bit more than violation of company policy. We have whether or not if it's deviation from the course and scope of his employment. Now, we have a lot of things in workers' compensation law that the question comes up. We have a traveling employees. These were not traveling employees. If you stop to buy lunch or take lunch, that's a different thing. But you're going down 5 miles off to the side of the road because you want to play basketball, or you're hurrying up to get to the job. It's not in the employer's best interest to drive. It has to be in the benefit of the employer's best interest to be in the course and scope also under the workers' compensation law. It just can't be in negative. I would say it's not that you have a violation of the policy that he's not. It's a combination that they have a policy and rules and regulations that he violated. If he violated that solely, the question is whether or not this would be a deviation from employment. He's not the driver. That's a deviation from employment. He didn't have a driver's license. He was going over the speed limit, talking on the phone, going blasting through the red. He never had been qualified to drive this car.
Mr. Sullivan, let me make sure I understand your position here. If we conclude that the state of the law is that the gross negligence of the co-employee is not enough to remove the workers' comp immunity from the employer, It may make the co-employee responsible and remove the co-employee from that protection. But if we say that's not enough, and you have to show an intentional misconduct or some intentional wrong on the part of the employee or an intentional act. And if we say that there are two ways that you can show that an intentional act has occurred that will take it out of the workers' community. One, there was an intent on the part of the employer to injure. You haven't alleged that, and I don't think that that's one of the issues. The only other way that you can show that intentional act is to establish that the employer engaged in conduct which was substantially certain to result in injury. And I think you've indicated you cannot meet that burden here.
I think it's weak. I don't think I can come up close to it. I could say, well, here you have the employer who, if we turned around and say.
Okay, so just to make sure, you're hinging your case and your argument on the legal argument that the gross negligence of the co-employee is sufficient to hold the employer responsible under vicarious liability and remove workers' comp immunity. That's your argument. Okay,
yes.
Just wanted to make sure. All right.
I think that in all good conscience, I just can't really. I could push it, but it'd be a big push to push the employer substantially certain.
Okay.
I don't like it. I don't like to say anything bad. I don't like it.
Let me go back to the issue about who the employer was and whether there was a material issue of fact about who the employer was. Who is the one source entity that you sued in the action, and what was the basis on which you sued that entity? Was it that it was the employer?
I sued and served One Source of Florida, and they answered. When I answered for records to show me payroll records, there's two things on this one also. Payroll records, they didn't have W-4s or W-2s or W-9s, whatever. They had some printout from One Source in Georgia. They're trying to say One Source in Georgia is the parent corporation and One Source of Florida is a subsidiary. And I think this is a question of fact.
But when you sued One Source of Florida, what was your basis of liability against One Source of Florida? Was it that they were the employer of the driver?
Yes, and it's an alternative. That's correct.
Well, as an alternative to what? What other basis?
Alternative pleading. In one section I have them as, in the other section I have the people who have the sign, and that goes.
Okay, but One Source of Florida, your only claim in the lawsuit against One Source of Florida was based upon an allegation that they were the employer of the driver. Is that correct?
No, sir. It's not exactly correct. That is one allegation that I had, but I also had allegations that Austin Irrigation was in a situation that I could, without a roadmap, Your Honor, I could not keep the entity straight, and so I tried to say this one and that one.
Okay, but in the alternative to One Source is liable because they were the employer, did you have a One Source is liable because of something else? Or is that the only claim you had against One Source?
I had another claim if One Source owned the vehicle and was not the employer.
Okay, so you had an alternative theory that said One Source is liable because they owned the vehicle.
Yes, sir.
Okay.
And that's why I'm saying that we should, maybe I'm all wet, maybe none of these, but Hall versus Talcott says they have to prove the negative. And what I'm saying is, even before the burden shifts to me, I have no burden. They have to prove the negative, and they have not proven the negative. We have the employer paying voluntarily workers' compensation benefits that Mr. Gurak said, I represent the employer is in One Source of Pennsylvania. That's where we are.
Is there an issue in this case about, in essence, waiver that your clients accepted workers' comp payments and that would It stopped them from now arguing that they weren't, that
The
workers'
Supreme
comp
Court
doesn't
put that to
apply.
rest, and I don't have the case here right now, but the Supreme Court put the rest. You can make a claim. We didn't make a claim. They paid voluntarily. But say we made a claim. If I don't pursue that and get all the benefits, not just workers' compensation benefits, because Turner says we have a situation, if you don't reach one of these plateaus, you don't get yourself out of immunity, then you're stuck with workers' compensation benefits. But if you're out because of the gross negligence of the co-employee, of the culpable negligence of the supervisor, of the employer raising the bar of the employer to substantially certain occurred, then you get all the benefits, except you can't duplicate it, and the Supreme Court says we have a proviso to do that also. You don't duplicate it, but you get all the wrongful death benefits that are pursuant to the Wrongful Death Act. Pain and suffering, all the problems that the people go through.
Your time's expired. Your time's expired, but I will give you 1 minute for rebuttal.
All right, so I'm sorry. Thank you very much.
Good morning. May it please the Court, my name is Paul Gunthar, and I'm the attorney for One Source Landscape Construction, Inc., which is one of 6 defendants in this particular case. I'll briefly say some of the background.
Which is what you said, one
of the 6,
okay.
there's 6 defendants
Okay.
initially in this case. And
What does the record show about different one-source entities? Are there more than one entities? How are they related to each other? Who's involved in this case, et cetera?
The record shows the president of One Source Landscape Construction, Inc., which is a Delaware corporation qualified to do business in Florida, stated in his affidavit that that company was the employer of Mr. Valentin. John Garrick, the attorney that represented One Source Landscape Construction, Inc., in the workers' compensation claim, filed an affidavit saying there was workman's compensation benefits available, and that he explained in his affidavit the relationship of the companies.
Is there an affidavit that they filed, or is there any evidence in the record that they produced that would be contrary to, to that affidavit in this particular record?
No, sir. There is no evidence in the record that disputes this. What they did do is they obtained some employment records from when they sent us a request to produce. They obtained some employment records which were maintained by a parent company in Atlanta, Georgia. And those employment records said right on them the name of the employer is One Source Landscape Construction, Inc. And if I can get back very quickly to Mr. Garrick, who was the attorney in the workers' compensation, he said One Source Holdings, Inc. is a parent company of One Source Landscape Construction, Inc. And Holdings provided workman's compensation insurance for its employees and its subsidiaries, of a wholly owned subsidiary, of which One Source Landscape Construction, Inc. was one. And that probably explains why on the notice of appearance it does say employer. This is not an authenticated document. This is just a piece of paper. And it was a notice of appearance filed by Mr. Garrick. It says employer, One Source Holdings, and it's got a different address. And on the CC down at the bottom of who's getting copies, it has One Source Bunnell, which is the headquarters of One Source Landscape Construction, Inc., the employer of Mr. Valentin. Okay.
Well, if One Source Florida was not the employer, or there was an issue of fact about whether they were an employer, would they have any liability under the plaintiff's theories anyway? Or were his theories based upon their role as the employer?
It is not pled in the complaint that One Source Landscape Construction, Inc. owned the vehicle and was not the employer and therefore was
What
vicariously
difference does
liable.
ownership of the vehicle make? Because if One Source Landscape Inc. owned the vehicle, workers' compensation immunity is going to apply anyway. If they didn't own the vehicle and someone else owned it, then maybe that owner could be a party to the lawsuit, but that wouldn't impact One Source Landscape Inc., would it? So what difference does it make who really owned the vehicle?
Theoretically,
If we say that it was, if we say it was your client and they own the vehicle, workers' comp immunity would apply unless they could establish, I think, an intentional tort or intentional act. But if it wasn't owned by your company and it was owned by somebody else, then perhaps that owner could be liable. So what difference does it make?
it really doesn't make any difference at all for One Source Landscape Construction, Inc. You know, who owned the vehicle, as Your Honor said.
But in any event, your client indicated or admitted that they owned it, didn't they? Or did they?
That has not come up.
That wasn't.
And those, and I can certainly explain the whole thing to you, but they're not facts in the record in this particular instance.
Don't go there.
So.
Okay.
Yes, sir.
All right, that was my question. I don't have any more.
So the facts established in the record that are undisputed, and even these unauthenticated documents don't really dispute them, are that One Source Landscape Construction, Inc. was the employer, that Mr. Valentin was in the scope and course of his employment. Unfortunately and tragically, there was an accident and an unauthorized person was driving the truck, but it is undoubted and undisputed that he was driving the truck on his way to a company job which was in the scope and course of his employment, and he was covered by workman's compensation insurance. If I can, and there is no evidence, and a case that I can cite on the unauthenticated documents that are just questions is and I think it's in my brief, it's the First North American Bank versus
Did you want to at least maybe even briefly, I think the primary argument that he's trying to make is that the co-employee was grossly negligent, and that's enough to hold the employer vicariously liable and therefore vitiate the workers' comp. I mean, I didn't know if you wanted to briefly address that. It seems to me like that would be the only other primary issue.
Well, there was the issue of deviation, which I thought I might address in a minute also. But first I'll address the issue. That's clearly not the law. The law is that for an employer to be liable, the actions of the employer had to be substantially certain to cause injury or death. That standard is above gross negligence. It's even been held to be above the culpable negligence manslaughter standard. So the fact that
that's really the only issue that they've attempted to raise. There's another way that they could vitiate the workers' comp immunity, which is to show that you had a specific intent to injure, and that's not even an issue in this case. So, and I don't even know that they've sufficiently raised the intentional act issue, but I think they may have attempted to some of the allegations in their pleadings, which, I think gross negligence and/or intentional misconduct.
I think the standard is intentionally injure or create circumstances where it's substantially certain.
Right, exactly. That's the only issue that we're dealing with in this case, isn't it? They've never alleged that you had a specific intent to injure, did they?
That's correct.
Okay.
And the substantial probability of injury, it relates in this case to you have to look at that from the conduct of the employer, not the conduct of the driver, correct?
Yes, sir, that would have to be, because all instances are situations, or not all instances, but most instances where an employee is hurt, it's through the carelessness, negligence, or gross negligence of a fellow employee. And there are cases, got down here, where an employee stabbed another employee, and the employer is not liable. Certainly that was an intentional act, and that was bad, but the employer didn't create the circumstance. It was still covered by workers' compensation in that particular case because they said the workplace contributed to the situation and that sort of thing, and they used a knife from the work, but the employer wasn't. So it's an example is in the same case that talks about the substantial certainty, that Turner versus PRC, and that was one where summary judgment had been granted, and it was reversed. And they said, no, there are questions of fact because the employer did things like had people mix volatile chemicals that could explode. They didn't have the proper equipment for mixing those. They removed the labels and misled the employees into thinking how dangerous it was. They had
A lot of the
prior
cases
explosions.
have to do with deceit and concealment and fraudulent conduct. and things
Exactly.
like that.
Each one of the cases that I found was really involved the employer misleading the employees about the safety of it. And even some really kind of, to me, outrageous circumstances that people were working in when they didn't deceive the employees and the employees had the chance to choose, the employer was not liable. If I may, I'd like to touch very briefly on the deviation. Here, in 440.092, subsection 4, talks about a traveling employee. And a traveling employee is any employee where travel is a necessary incident of his job. Mr. Valentin was in the scope and course of his employment because he was riding in a company truck on the way to a company job. The case that was cited by the plaintiff in this, the Burroughs case, where they said there was a question of whether they were deviating, was not a workers' comp case. It was a case to where a lady had been out of town on a job that was approximately 50 miles from her job. She stopped off at a bar and spent 5 hours in a bar, became legally drunk, and then at 10 o'clock at night proceeded home. And they said there was a real question of whether or not she was in the scope and course of her employment. And that was because of third-party liability. It was not a workers' comp case. This person was killed. Third-party liability is narrower than workers' comp. Workers' comp is very remedial in nature, and it's intended to help the people out. And I cited Liberty Mutual Insurance. And when the facts are not in dispute, as in this case, it is a question of law for the court to determine whether or not Mr. Valentin was in the scope and course of his employment. To be out of the scope and course of your employment, it requires a distinct departure for a non-essential personal errand. There was no distinct departure for a non-personal errand. And one of the cases I cited, the Lee versus Florida Pine and Cypress, was a situation that is somewhat analogous to this. There was an employee who was working at a plant far from home. It came time to return home. Apparently they stayed up there for a period of time. He caught a ride in a company
Do you mind if I ask, are there any other issues besides the deviation issue that you wanted to discuss?
see. The issue is that there's no evidence opposing it, there's no affidavits.
Just wanted to make sure you got everything covered for
The
them.
the deviation thing, the employer's entitled to workers' comp liability, we talked about that. And the vicarious liability is superseded by the workers' compensation law, which I think covers what we've talked. So I think I've hit the things, and I think the court's asked the right questions of me, and so if you've heard enough from me, I'm willing to.
I don't have any more questions.
I don't have any. No.
Okay.
Thank you
Did you
very
want me
much.
to finish on the Florida?
It's your time. If you want to use it,
Well, I just
we don't
want to
have
say
any more questions.
That was a case where an employee was returning home with an unlicensed
Okay.
driver,
Right.
wasn't authorized to drive, returning home from a company place, but the company provided transportation generally. He wasn't supposed to ride in that truck. He was injured. He was covered in workers' compensation insurance. That's it. Thank you.
Okay, thank you.
Thank you.
Thanks, Tom.
The cases on workers' compensation that were decided by a workers' compensation judge who sat as the jury. He wasn't ruling on a procedural motion of a summary judgment. He made a decision, and they said, based upon all the evidence, we want to have a decision based upon all the evidence, not to be shortchanged. There's so many issues there that we should go through and determine. And in the case I wanted to mention, State Farm Mutual Automobile Insurance Company versus Austin Outdoor, not Austin Irrigation, which is one of the defendants who got out, and they clearly shows they were owning the vehicle. Austin Outdoor and One Source, 918 Southern 2nd 446, cited in my brief. There was the same folks as we have here now, basically, in this. The record evidence emerging during discovery showed the truck involved in the accident bore a legend saying One Source Landscaping Golf. This one had a legend said Austin Irrigation. But basically, this case was cited for the affidavits were filed and said, well, they must have stolen the truck or whatever. It's not our truck. But basically, the appellate court must examine the record and any supporting evidence in light most favorable to the non-moving party. And that's all I'm asking for. We have evidence. Let us take it down the lane. We have to take some more trial material and deposition before trial. That's all we want to do, and have a chance to have this case tried in front of a jury, not in front of a workers' compensation judge. Or if we had to go in front of the workers' compensation, we've ended in no hearings in the workers' compensation judge, save one. I'm trying to get the insurance policy that says who the insured really is. Thank you.
Thank you, counsel.